You're muted, Sue.
Good evening.
Yeah, and Panna's muted as well. Panna, you're muted.
Good evening all. Sarvene Jai Shri Krishna, Jai Jinendra, Jai Swami Narayan, Sai Ram. Om Bhurbhuva Swaha Tatsaviturvarenyam Bhargo Devasya Dhimai Dhiyo Yona Prachodayat. Om Bhurbhuva Swaha Tatsaviturvarenyam Bhargo Devasya Dhimai Dhiyo Yona Prachodayat. Om Bhurbhuva Swaha Tatsaviturvarenyam Bhargo Devasya Dhimai Dhiyo Yona Prachodayat. Dhiyo Yona Prachodayat. Dhiyo Yona Prachodayat. As you all know, from my next screen you will see that we've lost a very special person, a legendary singer was laid to rest with full state honors on Sunday in the presence of her family at Mumbai Shivaji Park. The words cannot define a legend like Lataji. Only music can perhaps whisper to her everlasting greatness. The Nightingale of India, a voice which has resonated with and brought joy and happiness to millions around the world. I am anguished beyond words. the kind and caring Lata Didi had left us. She leaves a void in our nation that cannot be filled. The coming generations will remember her as a stalwart of Indian culture, whose melodious voice had an unparalleled ability to mesmerize people with her voice. May God bless her soul in eternal peace. Heartfelt condolences to her family and friends. Can I please take an opportunity of half a minute of silence in respect of Lata ji? Om Shanti, Shanti, Shanti. Once again, a very warm welcome from Women to Women, and to bring you this wonderful session with Cornerstone, a very reputable company called Cornerstone. We've got Anthony Hill and Sue, who are going to talk about Wills and lasting power. I've got my colleague Minu, who's going to give me company in questioning, Q&As. So if anybody's got all the questions, please write in the chat and we'll do Q&As at the end after Tony and Sue have done their bit. Any kind of questions that is, niggling you, put it down and we'll try and help you out. So can I please introduce you to Anthony Hill?
Hello there.
There you are. Welcome, Anthony, and Sue. Welcome.
Hello, everybody.
Hi there.
Can I leave you, Tony, now?
Hey, yeah. Well, first of all, thank you very much, Pam, for inviting us to your meeting, and especially on this auspicious evening, and for the honour of giving me the pleasure of introducing our speaker, Mrs. Sue O'Loughlin of Cornerstone Wheels. Sue is the founding director when Cornerstone Wheels was first set up over 16 years ago, and they are estate planning specialists helping clients protect assets and businesses for their families by providing expert professional advice and guidance. Tonight, Sue is going to talk about wills and lasting powers of attorney and give us her insights in some of the pitfalls to watch out for. The presentation, I think, will last about 30 minutes, so we've got plenty of time afterwards for discussions and any questions, as Panna was saying. Sue is highly qualified to speak with us tonight, having successfully passed both the Society of Wills and Estate Planners and Practitioners Diploma, and has the STEP Advanced Certificate in Will Preparation. I've known Sue for over 19 years. She has tremendous knowledge and experience, a huge work ethic, and is great fun to work with. I don't know anyone better able to speak with us about wills and lasting powers of attorney. So it gives me great pleasure to ask you to join me in welcoming to our virtual stage our speaker tonight, my business friend and colleague, Mrs. Sue O'Loughlin. Over to you, Sue.
Thank you, Tony. Thank you. That was a lovely introduction. I can't believe I've known you for 19 years. I must have only been a teenager when we met, obviously. But thank you. Very kind. And welcome, everybody. Lovely to see you all. Now, I have to say, I may have a few technical issues here because I'm working on a laptop that is not my usual one. So please bear with me. My own laptop has gone away to be repaired, so I'm getting used to this one, which I've only had this afternoon. So yeah, so we'll stride ahead and hopefully all will be well. So I've got a presentation. I'm going to hope that I can share the screen. There we go. Right. Hopefully everybody can see the presentation. Yeah, good. Okay, so the idea behind the presentation today, or this evening really, is to try and sort out some of the facts from the myths, because it seems to me that there's an awful lot of myths out there in the wills and estate planning world. So wills, powers of attorney, trusts, all of that. And what I'm going to try and do is address some of what I believe in my 20 years of experience in this industry, is to try and deal with your questions, obviously, but look at some of the most common misunderstandings and pitfalls, as Tony says, and hopefully point out where they may actually be true as opposed to what people think. The way I'm addressing this is I'm actually presenting some case studies. So these are all true stories with their names changed to protect the innocent, obviously. And a lot of these are based on probate cases that we have dealt with. So probate is where someone has died and their estate needs to be dealt with, and we've assisted the family in dealing with these. So these are all based on true stories, and I think it helps to see perhaps where things have gone wrong and how they could have gone right had people taken the right advice. So I hope you find this all helpful. There will be time for questions and answers at the end. So if you do have a question, I'm happy to go back to the slide or make a note of it, and we'll come back to it at the end. Okay, so I'm going to make a start. Now, forgive me if I'm not doing this as a normal slideshow, but because I'm having problems connecting with my server, I'm doing this all locally. So, yes, bear with the technical issues. So some of the most common myths are there's inheritance tax, which is a tax applied to your estate in the event of your death, that it doesn't apply to your home, that you only pay inheritance, or your beneficiaries only pay tax on everything that's not your home. The most common myth that I hear is if you're married or civil partnered, you don't need to worry about a will because everything will pass to your spouse or your civil partner. That simply is not true, and I'll come on and explain a bit more on that later. If you're married, if you're not married and you're not civil partnered, but you've been living together as a couple for more than 2 years, you don't need a will and you won't pay inheritance tax. That's another favourite myth. So I'm here as a myth buster, and again I will explain how those are myths on the next slide, or the next slides, I should say. If you have stepchildren, that they will inherit without a will because you've brought them up. If you've got children, and in the event of you and the children's father die together, that your mum can always be a guardian, even if you haven't made a will. And the last one is that married couples don't need to worry about powers of attorney until one of them gets dementia. Again, another favourite myth. So the facts, if you are a married couple with children and you have no will, then the actual fact is that your spouse or civil partner inherits everything, but only if the deceased's personal estate is less than 270,000. So if the person who's died is married and leaves behind a widow or a widower, if their estate, their personal estate, is less than 270,000, then the spouse will inherit everything. But if it's over that, then they won't. So if it's over 270, the spouse only inherits the first 270 plus the personal effects. This is if you're married. And half the remainder, and the other half is divided equally between any children at 18. Any jointly owned assets, such as a joint property or a joint bank account, will pass automatically between co-owners, whether they are married or not. Okay. So as a case study, again, names changed, but this is a probate case that I dealt with. So Sarah's husband, Ben, died very suddenly overnight from a brain aneurysm. Enormous shock. He was only in his very early 40s, and they had 2 young children. Their home was owned jointly, but they had a huge mortgage of $480,000. Ben had cash and ISAs worth $100,000 and had taken out life assurance of $500,000, but it wasn't written in trust. Sarah inherited their home automatically as the joint owner, but she was only entitled to the first 270 of Ben's estate, which included the life assurance. And so because his personal estate was 600,000, half of that, half of the remaining after the 270 was held in trust for their children. So instead of it being able to be used to clear the mortgage, as they had both intended, it had to be held in trust for the children, which completely left Sarah in a difficult position because she wasn't working. She was a homemaker. She had no income, and then she was left with the mortgage. And they'd done all the right things, they thought, but what they hadn't done is made a will. Had Ben made a will, leaving everything to Sarah, then she would have inherited everything, including the life assurance, and been able to use it for the purpose for which it was intended. Okay, so moving on. Hopefully you'll let me know if you can't hear me or can't see any of this, won't you? Good. Right, okay. So if you are an unmarried couple and have no will, then it doesn't matter how long you have been together. I see some really heartbreaking scenarios where a recent case where the partner had been with the deceased for 30 years, but he had never made a will, and he owned their home. So, so in this scenario, if the unmarried couple have no will, and if nothing is jointly owned, then the partner inherits nothing of the deceased's estate. If the deceased has left children, they inherit everything. And if no children, then everything passes to the deceased parents or siblings. But the partner inherits nothing unless it is jointly owned. The other impact, of course, of not being married or civil partnered is inheritance tax, because the partner of the deceased will only inherit $325,000 tax-free. Everything else is subject to inheritance tax at 40%. If you're married, there is no inheritance tax to pay between you at all. So, case study. So this was an unmarried couple with children and no will. So Tom's partner, Sophie, died very sadly from her second bout of breast cancer. They had a 20-month-old daughter and no will. Their home was worth $900,000 and was owned as joint tenants with a mortgage of $180,000. Sophie had cash of approximately $50,000, but had not been able to take out life insurance because, as she had insurance through work, she didn't feel that any other insurance was needed. Sadly, she had to give up work 6 months before she died due to ill health. And then, of course, because of her cancer, a second bout of cancer, she was uninsurable. So although Tom inherited the home automatically as the joint owner, Sophie's share was still taxable because they were unmarried. So the £50,000 cash that Sophie owned in her own name and her personal effects all went in trust for their daughter. And Tom, unfortunately, had a tax bill of $34,000 no cash from Sophie, no insurance, and left with a mortgage to pay. Very sad. So, so those are the 2 case studies for unmarried with children and married previously with children.
So can I interrupt, please?
Of course you can. Yes, do.
Can you make your screen bigger? Take the sides off and...
I would, but the trouble is, I would if I could. I'm not sure that the problem I've got is that this presentation is on my server, which this laptop is refusing to connect to this evening. It worked this afternoon, but it's not working this evening. So I'm worried that if I try and do anything, I might lose it and then I can't come back to it. What I will do is if I go through the presentation and then I'll try doing it as a slideshow and I'll run through the slides very, very quickly again at the end, assuming it works. Is that okay?
Yes, that should be fine. Also, I think I'll appreciate if you share the slides with me, so I'll put it in our WhatsApp group.
Oh, of course I will. Yes, absolutely, no problem. I'll send you the slides directly, and then you can share them and everyone can look at them at their leisure. That's no problem at all. I'll just make a note to do that.
Because it's not very visible at the moment.
No, I understand. I understand.
Okay.
But I will try doing it as a slideshow at the end. But if I get to the end and at least then I know that I've done the presentation, I'm just worried that because my connection to my server is just not working properly.
No problem. Thank you.
Even though it worked perfectly well this afternoon, it's just not wanting to play. Okay, but I will try and do it better. Once I've been through it, I'll run through the slides again and hopefully they will be bigger.
Lovely, thank you.
So if you are a single person and you have no will, then if you have parents, your estate will pass to your parents. And sometimes this means that it could go to a parent who is estranged or has never been known by the deceased, but then has to be traced, or it could be other relatives that have to be traced. So if it's not parents, it could be brothers and sisters or even cousins. And this could be, you know, where you haven't seen these people for many years. I'm dealing with a probate estate at the moment for someone who's died without a will, and their relatives are all in America, and we're having to trace them. And according to a distant cousin, the person who's died and the person or the family who are likely to inherit, they haven't spoken for 40 years. So it's crazy, and the expense of trying to trace these people is horrendous. So making a will could mean that well, it does mean that you can leave your estate to who you want it to, which may not be family at all. It could be charity, or it could be friends or cousins or people that you do want it to go to. If you're a single person, then again, even with a will, your estate is only £325,000 tax-free. Okay. So as a case study, this again was a very sad tale. So Lisa was age 47 and died in a car crash. She was pretty wealthy, had no children but many friends who were her family. She never made a will, but had been intending to make a will for a long time. In obtaining a grant of probate to deal with her estate, it actually transpired that although all of her friends believed her to be divorced and they knew that she had married, it turns out that in fact, Lisa was still married and had never gone through the divorce process. We then found out that her husband had been quite abusive and violent, and so she'd been very scared of him and did not want him to know where she lived, so she never filed the divorce papers. She just never did it. And very sadly, because she died without a will, her husband the very person she didn't want to inherit, inherited everything. And it was a considerable estate because although he was estranged to her, none of her family or friends could make a claim because he always had a prior claim, and she had no children, so no one else. So if she'd had children, part of the estate would have gone to them. But because she had no children and she was still legally married, her husband, her ex-husband or separated husband, estranged husband is probably the best way to describe it, inherited everything. Lisa would probably have wanted her friends to benefit, but because she didn't make a will, that never happened. Okay, so I'm just having a quick chat about will trusts and the fact that sometimes trusts can help with an estate to protect your home from things like if you're on a second marriage and you have children from a previous marriage but have been remarried, then sometimes you want to make sure that your estate is protected in some way for your own children, even though you'd like your new partner husband to inherit some of your estate. Your trust can also protect your home from the costs of long-term care. So when I say trust, I'm talking about trusts that are included in a will. And therefore nothing happens until one of the parties passes away. This, as this slide says, mirror wills only guarantee what happens on first death, whereas trusts allow a little bit more control of your estate in between the first one of a couple dying and the second one of a couple dying. Now that time scale between first couple dying and second one of a couple dying could be 3 weeks, 3 months, 30 years. And anything could happen in that time. If you died and your husband could remarry, obviously after many, many years of mourning, they could remarry, and therefore your assets could all pass to a new partner or substantially pass to your husband's new partner. And you might actually want your children to have some guarantee that they are going to inherit. There's no guarantee that after your death, your new partner won't change their will and leave all of your assets to their own children or to their own friends or their own relatives. There's nothing to say that they have to leave the estate to your children after they've passed away if you are the first one to die. So trusts give you a bit more what we call asset protection against whatever might happen in between your death and your spouse's death. So as a case study, this is how children can lose their inheritance. So John and Amy owned their home and the Wills left everything to each other. Amy died and John remarried. Amy died and John inherited everything. John married again to Julie, who was an old family friend. They purchased a new property together jointly, but John died very sadly before he and Julie could make new wills. The house passed automatically to Julie, and because she was John's spouse, she was also entitled to the first 270,000 of his estate. John and Amy's children inherited nothing on his death or on Julie's death because Julie's estate left everything to her own children and not to John and Amy's children. However, a trust in Amy's will could have meant that on John's death, the estate passed back to their children, and that would have had some guarantee that at least John and Amy's children inherited something from their joint estate. As it was, they inherited nothing from either parent. And the only beneficiaries from John, Amy, and Julie were Julie's children. Okay, and a trust would have protected that. So I'm going to also now talk about what happens if you become unable to manage your affairs. So the Ministry of Justice is very keen to encourage the will writing community, of which Tony and I are members, that when we talk to anybody about writing a will, they should also be encouraged to make powers of attorney. So even if you are married, you are not able to deal with each other's assets. So if you have a bank account that is in your name, or an ISA, which has to be in your name only, your husband cannot deal with your accounts if you become unable to manage things for yourself. Now, we all sort of think about this meaning that you might get dementia. But in fact, it could be that you have an accident, or even that you're physically unable. Anyone can have a stroke and become temporarily unable to manage things for themselves, or maybe you have a problem with your eyesight or arthritis as we get older. It's not all just about mental incapacity. So what you can do is to take out or have drawn up lasting powers of attorney documents that enable you to choose who you would want to manage your affairs in the event that you become unable to do so yourself. And just to be clear, this is not about handing over control. It's a bit like doing a will. You have to do it when you're well and able, so that in the event that you're not, you have something in place that means that people can deal with things on your behalf. In lots of ways, it's more important than a will to do powers of attorney, because having a power of attorney makes life easier for those to be able to provide you with the support that you need during your lifetime. If you don't have a will, things may not happen the way you want it to, but it will get sorted out eventually. Without a power of attorney in place in your lifetime, it could just go on and on and on. And the only time that anyone has any ability to deal with things is to apply to the Court of Protection. The Court of Protection have exorbitant fees and are currently taking about a year to address applications to be able to deal with things on your behalf. So someone has to apply to the Court of Protection. Their fees are on application, and also yearly you have to provide them with a set of accounts every year of what you have done on behalf of your loved one. And they also charge fees then for checking those accounts. So it's a very difficult scenario, and most people try to avoid this at all costs by taking out powers of attorney, so that in the event of anything happening to them, they can have an attorney in place already and able to deal with things on their behalf should the need arise. Okay, so as a case study, now I don't know how many of you are aware of the TV presenter and radio presenter Kate Garraway and her husband Derek. So Derek contracted COVID in March 2020 and was in a coma in a hospital within days. How he survived, we'll never know, but he still is not okay now. Now, Kate and Derek had sorted their wills, not with us, I hasten to add, but I thought this is what Kate is reported to have said to the media. They thought they were too young to do lasting powers of attorney. And as Derek's name is on most of the bills and insurance policies, and his name is on the car, so it's his car that they shared. His name was on the insurance, so she couldn't renew the insurance to be able to drive the car. He had his income was still being paid, but paid into his individual bank account, so Kate could not access it. So she had the most terrible time trying to deal with Derek being in hospital, not knowing if he was going to survive. And then to add to the stress and de-stress of that scenario, neither could she deal with anything on Derek's behalf or have access to his accounts or his income or anything. So that's, you know, a fairly common situation, but also quite a high profile one that most people will be aware of. Had they done powers of attorney, they would have just gone into action straight away, and Kate would have had a much, much easier time. Okay, so why Cornerstone Wheels? As Tony has done such a wonderful introduction, I hope this slide isn't entirely necessary, but we are qualified estate planners and probate specialists. So we're not just will writers. We give advice on inheritance tax, and we try to mitigate inheritance tax for you as much as possible, but we look at the big picture. So it's not just a case of, look, so sitting down with an instruction form and saying, what do you want to do? Where do you want everything to go? Who do you want to benefit? But it's having a look at the whole big picture of, do you have inheritance tax a problem? Can we solve it for you? What is your tax situation? What can we advise you to be able to deal with your estate in the best way possible in the event of you or your partner's death? We're not the cheapest, but we're certainly not expensive either. And we, compared to most London solicitors' fees, we certainly are very competitive. As Tony said, we're members of the Society of Trust and Estate Practitioners, which means we're qualified to give advice on inheritance tax, and we're also members and qualified members of the Society of Will Writers. And having been in this business now for almost 20 years, hard to believe, I know, we do have a very trusted track record. Okay, so that's the end of my presentation. I am just going to see if I can do this as a slideshow. Bear with me. I'm not sure it's going to. Right, hold on a moment. Can you all see that?
Yes.
Okay, thank you. So hopefully that is now bigger and better. I'm just hoping this will work. So I'm going to run through the slides again if it's not too painful for everyone, but I'm not going to obviously do the presentation again, and I will share the slides with you. So I talked about the myths of inheritance tax and whether you're, the fact that if you're married, everything doesn't pass automatically between you without a will. If you're unmarried, but being together for, it doesn't matter how long you've been together, you need a will to make sure you inherit from each other. The facts about what, if you're a married couple with children, without a will, this is the situation. So all these figures you can obviously look at your leisure when you've got the slides. So if you're a married couple with children and a will, this is the case study with Sarah and Ben and their young children. Unmarried couple, no will, the partner inherits nothing from the deceased unless the assets are jointly owned. And of course, inheritance tax is payable over £325,000. An unmarried couple with children and no will. This was the case where, unfortunately, Sophie was uninsurable, and because Tom had to pay inheritance tax on Sophie's share, he's now left with a mortgage, no insurance, and a bill to pay. And the single person no will, assets will pass to parents, then siblings, then nieces, nephews, but not necessarily anybody that you want it to go to. And sometimes this can be people that you haven't spoken to or haven't seen or have never known, but They are your family and therefore could inherit. And I was explaining the case of Lisa, whose ex-husband or estranged husband inherited everything just because she didn't get around to making a will. Will trust, we talked about asset protection and retaining some control over what happens after your death. And that was the story of John and Amy, who Amy died and John remarried, and their children inherited nothing. Powers of attorney and how important they are to be able to manage your day-to-day affairs. And the hopefully improving case of Kate Garraway and her husband Derek, and why you should look to us to help with your will writing and estate planning needs. Okay, so I'm going to stop sharing and come back. So hopefully that covered everything that you were expecting it to cover. If there's any questions, fire away and I'll do my best to deal with them. Could someone give me an idea of what time you would like to finish, just so I can?
The latest is 9:30.
Okay, all right.
So we have got time.
Okay, that's fine.
Right. I've got the first question directly to me. What happens if you don't have a health and welfare P of A?
Power of attorney, yeah.
Power of attorney, if not covered in the talk.
Okay, so a power of attorney, there are two different types of power of attorney. So one is for financial affairs and one is for health and welfare matters. I always recommend both. So if you don't have a health and welfare power of attorney, it means that you don't have a voice if you can't speak for yourself. So the benefit of having a health and welfare power of attorney is that you can appoint someone to speak on your behalf about what your wishes are, for ranging from things about where you live, what diet you have, what treatment you receive, whether in fact you receive life-sustaining treatment or not, in the event that you are in a very bad way, and it's not necessarily in your best interest for you to receive life-sustaining treatment. So your attorneys can challenge the medical profession. They can't get anyone in the medical profession to do anything against their code of practice or anything that is illegal, but they can challenge decisions or request things on your behalf. So I will try very quickly just to share a very brief personal story of my own. So this was about my mother, who did have dementia, and I had a health and welfare power of attorney for her. And she had been in hospital with pneumonia and she was getting better. So she had dementia, and she wasn't really, really bad with dementia, but she certainly was very disorientated, had been in hospital for 2 weeks, and they phoned me up to say I needed to come and collect her and take her home. And I said, well, I live 100 miles away, so I can't get there until the weekend or Friday at the earliest. So they said, well, we're going to have to send her home in a taxi. This is truly what the hospital told me. So I said, are you seriously telling me that my mother, who was at the time 82, has dementia, and you're going to send her home in a taxi? My brother lived locally to her, but he was abroad at the time. So I said, you know, she doesn't have anyone locally who can be there for her. And they said, oh, we've assessed her and she's recovered from the pneumonia and we need her bed. So I'm afraid someone will have to come and collect her, or we'll send her home in a taxi. So I said, well, actually, you've assessed her, but I have power of attorney for my mother. And as you know, she has limited capacity. So legally, you cannot assess her without me or my brother being present, because I have a health and welfare power of attorney. So you can't assess her without me there. You can't assess that she is able to leave hospital. I won't be able to get there till Friday. So I will be there and I will do the assessment with you on Friday when I come. And I'd like someone who's qualified to assess my mother as a geriatrician present when we do the assessment. So they had no choice. They had to wait for me and they didn't send her home in a taxi. If I didn't have a health and welfare power of attorney, she would have gone home in a taxi and there would be nothing I could do about it. I mean, I wouldn't have had her go home. I would have found a friend or someone to go and collect her. But if I didn't have anyone, that would have been the scenario, which I was horrified over. Absolutely horrified that the hospital would do that. So I thanked God, and so did my brother, that we had done powers of attorney for my mother when we did.
But there again, Sue, if you had given permission for the taxi to drop her off at home, would you have said yes?
Would what, sorry?
If you had given the permission for the taxi to bring your mom at home, would you not accept that? If they had agreed to give you a taxi?
Right. No, because my mother had been in hospital for 2 weeks. She had dementia. So had she gone home, she didn't remember home or where she lived. So to go home on her own with dementia, she was terribly disorientated in hospital. So would have been even more disorientated going home on her own with no one familiar there. A taxi driver would have just dropped her at the door. You know, we didn't even know she had her keys with her or anything because she'd been rushed to hospital with pneumonia. So no, that would have been awful for me. That would have been absolutely awful. So I was just very, very glad that that wasn't the scenario. There was no one at home for her.
Yeah.
So it would have been dreadful. So hopefully that answers the question as to why it's important to do health and welfare and what could potentially happen if you don't have a health and welfare power of attorney. Okay. Another question?
Mino.
Yeah. Hi, Susan.
Hello. Hello, Mino.
Hear you and your advice is amazing. This is one of the first questions we got through. So it's saying, how do you write insurance policy or whatever in a trust ?
Well,
a paper document or something else?
That's a really good question. So it can depend on the insurance policy. Not all insurance policies are able to be written into trust, but most of the more recent ones are. And the best thing to do is to contact the insurance company, or if you've taken out insurance through a financial advisor, go to them first. But if you approach the company that you have the insurance with and say that you would like the policy written in trust, then they will generally send you the trust forms to sign. Tony, this is probably more your area. Would you have anything to add to that?
That's exactly right. As you know, I worked for 21 years as a financial advisor, and that's exactly what I did with my own policies. Got in touch with the insurance company. They then sent the correct forms to set up the trust, which you then complete and send those off to the insurance company, and they're witnessed and then they're kept with the policy itself. So that's available. So if and when you die, then that document is always available when the estate has been sorted out.
Okay. Great.
Yes. Hope that helps. Yeah.
And
that's a very good question.
Yeah, and there's usually no charge for setting it up by the insurance company. They don't charge for doing that.
Okay.
Yeah.
Another question directly to me. Why are some companies cheaper than others?
I suppose that's the same as anything. I mean, to a degree, you get what you pay for, but not always the case in this industry. I mean, we try to keep very aware of the market and what is reasonable to charge, but also it's very difficult because sometimes you're comparing apples with pears, because one will writer is very different to another. The lack of knowledge in this industry, and it's not a regulated industry, the lack of knowledge, even by solicitors, sometimes astounds me. And we do lots of continuous development. We go to a lot of conferences, we listen to a lot of webinars to try and keep abreast of the latest laws and the latest ideas for tax planning, even just, you know, cases that have gone through the courts that may be relevant to things that we advise people, but not all people do that. And, you know, and yet they can charge more than we do. So it's very, very variable. It's a bit like, you know, I suppose, why does one clothes shop sell clothes for a certain price and the same clothes in another shop are twice as much? It's not the quality of the clothes. It may be perhaps the quality of the salesperson, but it's certainly not always the quality of the clothes.
True.
It's more to do with the service that you provide. That's what it is.
Yeah. The service, the Cornerstone service also provides to look after your will if they have written for you.
Yes, yes, that's very
If
true.
something happens to you and nobody knows where to look for your will, always contact Cornerstone. If your will is with them, they'll issue it again.
Yes, exactly.
Yeah. Yours.
Next question. How long does it take to administer an interstate will?
An interstate will. Oh, okay. An intestate will. Oh, yes, sorry. Intestate, meaning where someone's died without a will. Okay, that's not an easy question to answer because it really depends on a number of factors. So if someone dies without a will, depending on their family scenario, so if they leave say a wife and children, for example, and someone's died, then it's obvious who their beneficiaries would be. But if they don't leave a wife and they don't leave children, or a husband and children, or whatever, then, you know, then it's the process starts of having to find their relatives and understand who their relatives are. So that requires a family tree to be done. And how easy that might be might depend on how many relatives they've got. It also, in dealing with someone's estate where they don't leave a will, you've got someone has to apply to administer it, and that is normally a next of kin. So then you've got the process of doing the family tree to find the next of kin, because the person who is obligated to deal with the estate is whoever the nearest relative is, and sometimes you don't know who that is. So if you make a will, you appoint an executor of the will who is able and appointed within the will as the person able to deal with your estate. Now, they don't have to be your next of kin, because if you're making a will, that's your choice. But if there is no will, then the only person who can apply is a next of kin, but you've got to find them first. And also, if you're administering an estate where someone has died without a will, you may not know who is able to deal with the will and then who's able to tell you what the assets are in the estate. So it depends on the person who's died, what their assets are, and what their immediate family setup is like. If they do have an immediate family, it won't take anywhere near the length of time that it would if they don't have any immediate family. Yeah?
The longest one that I know about was 30 years to do the administration, because the will had been poorly drafted on the estate. They had a cottage with a tenant, and the will simply said to sell the cottage at the best market price. And they had to wait until the tenant died in order to be able to get the best market price. And that was 30 years later.
My goodness me, that's bad, isn't it? Yes. So that again is lack of knowledge by sometimes people try to do their own wills, and you know, I know it seems like it's it's a good idea, but it's such a false economy, because there are so many pitfalls to doing a will. I've never yet seen a homemade will that was fit for purpose. I really haven't. Unfortunately, people don't know what they don't know. So you can make assumptions about, I'll just write down what I want to happen. But that tale that Tony's just said absolutely demonstrates where you can go massively wrong if you don't know what you're doing. And even, you know, some people who are will instruction takers can get it very wrong if they're not properly trained. Yeah. So, so the answer to the question of how long does it take to administer an intestate case, it's a really difficult answer. It just depends on very many variables. But yes, it's clear if the family is present and available, then it will take much less time than if they're not. I hope that helps the question.
Yes, I've got another one directly come to me. What service and documents should be provided by the company so we don't have to worry afterwards?
I'm not sure in what context this is. So in the event that you've done a will with us, for example, and we store your will for you, is that what the question is? So so we would provide you with copies of your will.
Okay, let her explain what she means.
Okay.
Actually, I'm looking for the power of attorney documents, and as I said, there's some companies charges more or less than the others. So is there a set of documents that is required for you to get from the company, so then you're not worried afterwards, because there is something called Office of Public Guardian as well, that you need to get that to get it registered with government, so it's in the database. So in all that context, I wanted to know, are there any set amount of documents and written in certain way that you need to have in order to make the power of attorney work for whoever it is?
Yes, thank you for clarifying that. Yes, so basically the power of attorney documents are government documents. So what we do is we help people fill out the documents and advise them on a bit like a will, on who they should choose as their attorneys, how it's filled in, and also making sure that everyone who they want, so the people making the powers of attorney and their attorneys all get to sign the documents in the right order and in the right way. So then they go off, as you quite rightly said, the powers of attorney documents themselves are signed by the person making the power of attorney and all of their attorneys. When that's done, they go to be registered at the government department called the Office of the Public Guardian. And the Office of the Public Guardian are a subsidiary of the Court of Protection, which I mentioned before, is the government office that deals with the affairs of vulnerable clients. So the Office of the Public Guardian specifically is the government department that deals with the processing and registration of powers of attorney. So when they are registered, they are usable. If they are not registered documents, they are not usable. They're still legal documents, but they're not usable. So we always recommend when we do powers of attorney that we take on the process of the registration, and with the Office of the Public Guardian, we make sure that the documents have all been signed correctly, and then we send them to be registered. We check that when they come back, they've been correctly registered. And then we either send the documents back to the clients for use, future use, or if they're not immediately needed, we often store them with your wills. Okay, so there are specific documents that have to be filled in, and there is a specific process that has to be followed. Does that help? I hope.
She's saying yes.
Good, good. Thank you.
Also, I just wanted to know that there are separate charges for registering your powers of attorney with the Office of Public Guardian. Is that right? Am I right in saying that each document, whether it's health and welfare or finance one, they each have a separate charge for registering with the government? Is that right?
That's right. So the registration fee at the Office of the Public Guardian is £82 per document. So if you have one for health and welfare and one for financial, that would be £164 registration fee. However, if your income is less than £12,000 gross a year, and sometimes some of our elderly clients only get a state pension. They don't have any other income. So a state pension would be below the £12,000 a year gross figure. And so therefore their fee is reduced by 50%. So it's only £41 per document. So if I go and see a couple, sometimes the husband may have, sorry, this sounds terribly traditional, but if the husband has a works pension that they have and the wife has been the homemaker and doesn't have a work pension but only has a state pension, then sometimes the husband has to pay the full fee of £82 per document, but the wife can have the reduction at £41 per document. Does that help, hopefully?
Yes.
Yeah. Yeah.
No.
Okay.
Next.
Okay.
Yeah. Go for it.
Okay. This one is like asking you if she's correct or not. So if you're single, if you are single, your income/savings, not your house, will be subject to inheritance tax after the 325k with a will. Is that correct?
No, all of your estate. So at your home, your cash, your personal effects, your jewelry, everything is potentially subject to inheritance tax over the 325,000. Okay, including your home.
Including, okay.
Yes, yes. So everything you own as a single person is subject to inheritance tax over 325,000. However, I am just going to qualify that because you could be single but have children. Okay, so if you are a single person but you have children and you are leaving your home to your children, then you do get an extra allowance for your home. And this is called a residence allowance, but it has to be if you are leaving your home to your children. So if you are single and you have no children, but have a partner, but an unmarried partner, the residence allowance is not applicable. Or if you're leaving your assets to your parents or your brothers and sisters or whatever, you don't get this extra allowance. But if you are single and you're leaving your home to your children or grandchildren or even stepchildren, you get an extra allowance of £175,000. So added to the 325,000, that means you can leave potentially £500,000 tax-free, but only if you have children or grandchildren or stepchildren.
Or nephews?
No. Absolutely not. Does not apply to nephews. Only your bloodline or stepchildren.
Okay.
Okay.
Mm-hmm.
So, but if you are a single person with no children, you have 325,000, and everything else is taxed at 40%.
How do you put house in the trust? Isn't a statement written in the will or something separate has to be drawn up?
Usually it is when I'm talking to clients, I usually advise that it's done within a will. So the reason I say that is because if you put your home in a trust in your lifetime, there are other tax consequences that may not give you the outcome that you expect. So say, for example, if you, and this also applies to not even putting your home in a trust, but you put your home, say, in your children's name, which I just go, oh no, please tell me you haven't done that, because that's really bad. Okay, I'll come back to why in a minute. But if you give away something in your lifetime that you still benefit from as if you owned it, as if you had never given it away, as such as your home. So if you change your home into your children's names, or you give your home into a trust, it's called a gift with reservation of benefit. In other words, you are giving it, but it's not a true gift because you are reserving all the benefit of it. So unfortunately, HMRC consider that as a gift with a reservation of benefit, so to still be part of your estate, and therefore you pay tax on it as if you owned it. Okay, so most of the time, I don't advise people to do that if it's inheritance tax they're trying to avoid, because it doesn't work. If you're looking to protect your home against care fees, that's a different matter. But again, I generally prefer that to be done via a will, because it's a less intrusive way of dealing with asset protection. Just going back for a moment to don't ever put your home in your children's name. Quite a number of years ago, and we're probably going back about 15 years, I sat down with a client who had a really good friend who had was an elderly lady, well, elderly-ish lady, and she had a home worth over £1 million, and she had one son who was in the army, and she was worried about him paying inheritance tax, so she put her home in his name. He came out of the army and got married to a lady from the Philippines. And then they went back to the Philippines to live, and he died in a car crash. And because under Philippine law, his wife inherited the home, and they had no children, so she inherited the home, and the wife promptly sold the property, and there is nothing whatsoever that the mother could do about it. So she had lost her only child and her home within the space of a year. So very sad. So the thing is, lovely as your children will, I'm sure, are, you never know what might happen in their life. You never know if they might get divorced or die before you or go bankrupt, all of which could mean that your home would be vulnerable. So I always try to really, really discourage people from doing anything that would make them vulnerable in their home. No one wants to feel vulnerable, but as we get older, the idea that you might lose your home and there is nothing you could do about it is quite horrible, really. So if you do ever think of doing anything like that, or anyone suggests that to you, it does not save inheritance tax unless you pay rent to the person you've given it to. But even then, forget the inheritance tax issue, you've still got the whole issue of you never know what's going to happen in your children's lives. And if they get divorced even, which is the lesser of all the evils from dying or going bankrupt perhaps, you know, your home is still part of that divorce settlement because your child owns it. Yeah, so you still might have to lose some of it. It might have to be sold to pay off your ex-daughter-in-law or son-in-law. You never know. Okay, so I always encourage people to do asset protection via their will, because then it means that you're not vulnerable yourself in your lifetime. You do it in such a way that doesn't leave your spouse or partner vulnerable in their lifetime either. And it's only when what you're doing is making sure that your children inherit something, but it's not leaving you exposed to whatever happens in other people's lives that may have a very negative impact on yours.
Good.
Okay, hope that helps.
Okay, to finish up that last question I did, I know Cornerstone charges varies, but she's saying, what are your charges to do a will, and where are you based?
Okay, so we're based in Camberley in Surrey, but I do home visits. And I also do appointments over wonderful Zoom. So during COVID, we're busier than ever because I think everybody suddenly felt very mortal all of a sudden and worried that they hadn't got their affairs in order. And quite rightly so. And so we were busier than ever, but not able to see clients face to face, we saw a lot of clients over Zoom calls, and that's fine. And sometimes I might start off the conversation on Zoom, do the instructions, and maybe go and see the clients to get the will signed. Or for elderly clients, I would always rather see them face to face. So I do go out and do home appointments, depending on, so long as someone doesn't live in France or Scotland or Yorkshire even. So we are based in Surrey, but that doesn't mean that we can't see clients who are further afield. I actually saw clients in the very tip of Wales over COVID over Zoom, which was fine. Yeah. So Zoom has made everything a lot more accessible. So our charges, so we do work on fixed fees. So for basic wills. And then our charges vary for other things that clients might want to do, because it does then depend on the complexity of what you want to do and what your setup is, and other assets come into play then. So for basic wills, for a single person, our fee is £295, including VAT. And for a couple, for basic wills, it's £495, including VAT. And we have not put our prices up over COVID. In fact, I don't think they've changed it's got to be more than 5 years. I don't think they've changed in 5 years, have they, Tony? No, I think it's much longer than that, actually. But we certainly haven't put up our fees.
Right.
Well, I know Tony has seen me 3-4 times, maybe. Mm-hmm.
Yeah.
Mina?
And we don't charge for those visits. Whereas I think other professional firms, maybe solicitors, would charge. As soon as you they set the clock going as soon as you open the door, sort of thing.
But that's true, because I do sometimes say to clients, home visits are different, but if you're having a Zoom call, sometimes I might see a client on Zoom, take instructions, send them draft wills, and then they may have questions from the draft wills. So I'll say, well, look, let's have a Zoom call and we can have a chat about the drafts, and I'll go through it line by line. And that's so much easier than if I had to go and visit them, because then I might have to charge extra for an additional visit. Whereas over Zoom, I don't even have to leave my cup of tea behind. So perfect.
Yeah.
Okay. So the next question is the 325 tax-free per person that inherits it? If not, how is the tax apportioned between the various people that have inherited the estate?
That's a very good question. Not that they're not all very good questions, but that is a very good question. Okay, so basically, the 325 is not per beneficiary. It's an estate tax. So it's a tax that is applied to whatever you have in your assets. So as I mentioned before, if you have a home and you have cash and jewelry and stuff, car, yachts, whatever in France, whatever you've got is then assessed for its value. and the estate, the tax is applied to the estate. If you're leaving your estate to your spouse, then there is no tax whatsoever. Even if you're worth 50 million, but you are both UK domiciled and you are married or civil partnered, there is no inheritance tax to pay between you at all. However, if you're not married and you're leaving your estate either to children or a partner, then the tax is levied on the estate before anyone gets everything. So if you imagine this is the pot, or let me have my glass of water. So this is the pot, and that is filled with your estate. The top slice is free and everything else is subject to tax, and the taxman gets his cut, and then whatever's left is divided between your beneficiaries or in whatever way your will says. So unlike Europe, where most countries in Europe, you have an inheritance tax threshold per child or per beneficiary, and the distance from the deceased to the beneficiary. So children get a higher threshold than grandchildren, for example. That's how it works in Europe. That is not how it works in the UK. So in fact, your children get exactly the same tax allowance if you're not leaving your home to them. So if you have no home, your children get exactly the same tax allowance as if you are leaving your estate to your next door neighbour. There is no benefit to them because it's an estate tax, and unless it's going to your spouse or civil partner, it is taxable at the same rate. The only addition that children get is if you are leaving them your home, and you get an extra allowance for them if you're leaving them your home. Yeah, it's very unfair. In Europe, the more children you have, the less tax you pay, but not so in the UK.
Okay. If you are adopted, would the adopter's money stroke asset to automatically to them if a will were not written? If a will were written with express wish to omit the adopted children, could the adopted children contest the will?
Right. So the answer to the last bit of that question is yes. An adopted child is treated by law exactly the same as a natural blood child. So long as there has been a legal adoption process, then yes, they could contest the will if they are explicitly excluded. So they have as much rights as a blood child. Okay. What they can't do as an adopted child is benefit from their natural parents' estate, unless the natural parents, the birth parents, have left a will that explicitly includes them. Once a child has been adopted by its adoptive parents, all the legal rights apply to the adoptive parents and the adopted child. Okay, the adoptive parents and the adopted child. So that is the legal arrangement. They are treated then as if they were their own by law. Okay, and they have no legal claim on their birth parents' estate.
Okay, Minu.
Is it possible to draw up a will with lasting power of attorney built in?
No. They are mutually exclusive. Very, very specifically so. So a lasting power of attorney is only applicable in your lifetime. It has no power after death. A will is the complete opposite. A will has no power in your lifetime and is only applicable after death. So they are mutually exclusive. So no, very definitely not. Apart from which, the powers of attorney are very specifically a government format. A will does not have any, there are obviously preferable inclusions in a will. And although I wouldn't advise it, in theory, you can make a will in any format you like. Okay, if you're a member of the armed forces, you can even make a verbal will, but only if you're about to go to war.
Okay. So who holds the verbal will then? It's on the table, I take it.
It's what, sorry, Hannah, what's that, sorry?
When you say it, oh, unless you make a verbal will.
Oh, yes, so somebody could make a recording of your will, but that is not that is not usable in normal circumstances. It's only ever acceptable if you are a member of the armed forces and you're about to go off to war, that a verbal will is in any way an acceptable legal will.
Okay. Okay.
Hopefully none of us will find ourselves in that situation, because we'll have all done our wills properly anyway by then. But hopefully we'll never find ourselves in that situation in any event.
Okay, a joint bank account with anyone, for example, children, sister, friend, etc. Would the money in that account automatically go to the right holder? Same for the property, jointly held with a friend, etc. Would that automatically go to the friend?
Yes, it would. And this is where the law in the English law is very quirky. So this concept of a joint ownership is very peculiar to English law. But it's a bit dangerous in lots of ways as well, if people are unaware of it. So if you own a property or a bank account jointly with anyone, then in the event of either of the co-owners dying, the joint asset automatically passes to whoever is the co-owner under the law of survivorship. And the law of survivorship is a higher law than the law of your will. Okay, so if you said, I want to leave my house to my children, but your house is jointly owned with your husband will automatically inherit your house and it will never go to your children despite what your will says. Okay, because if you are the first to die, it will always pass to the co-owner. Okay, so the thing to remember with this is that just because it passes to the other person, it doesn't mean that it passes to them in free of inheritance tax. The only person who will inherit tax-free anything is your spouse or civil partner. So if you own your home with your child jointly, then let's say you have 3 children, but you jointly own your home with one child, then that child will inherit the property on your death and not all 3 children, even if your will leaves everything equally between your 3 children. But that property won't go tax-free to that one child if it's over 325 or over 500 with the extra residence allowance. That child will have to pay tax on it because they've inherited it.
And to avoid that, is there something we should be doing it?
Well, you can change for a property, you can change it from being joint ownership to something called tenants in common. So there are 2 ways that you can own a property. One is joint tenants and one is as tenants in common. Now, I'm just going to see if I can find something to demonstrate this better as a prop. And I can't find it. Okay. I'll just have to use my glasses. Right. So if this is your home and it is jointly owned by 2 people, then there is only one share of the whole 100%. And you both own that one share. So if one person dies, the other one just carries on owning the whole one share. And you don't have a share that you can leave in your will because you both own the one share. One dies, the other one just carries on owning the whole share. Okay, and that, as I say, is the law of survivorship that is only applicable to jointly held assets like a bank account or a property. For your property, you can change the way you own your home from being joint tenants to tenants in common. So as tenants in common, these are my glasses, I hope you can see them, 2 pairs. As tenants in common, you've got one home, but there are 2 separate shares, and each party owns their own share. So if they said, I want to leave my share to my children, they can do that. The other share is still owned by the other party, and that's theirs. You can't direct what happens to theirs, but you can direct what happens to yours. Okay, but you have to be on a property, you have to be tenants in common to be able to do that. If you are joint tenants, the law already has given the property to the surviving owner. Does that make sense?
Yes. So what my next question to add on that is, say I've got this property and only one name is there and the partner's name is not there. Does it affect anyway? So one partner goes, automatically the house goes to your partner
Yes.
without my name being in there?
Without what, sorry?
Without my name being in that house?
Oh, no, sorry. No, if your name is, so if the partner owns the property in their own name,
Yeah.
then it's not going to be dealt with in the event of your death, because it will only be their death.
Okay.
Sorry, I think I've misunderstood that.
Yeah. No, because Tony, correct me, when we did our will, Kishore's got his name on the house, and I haven't got my name on the house itself. But I think when we discussed it, you said automatically it will come on to me, and then from
Because the will says it goes to you.
Oh, okay.
Okay, if he hadn't made a will that left it to you, it wouldn't automatically all go to you.
Oh, okay.
But because the will leaves it to you, that's why it works.
Okay. So will there be any extra charges if my name was not on it? Probate. Will the probate take longer procedures?
The probate wouldn't take longer, but you would have to do some conveyancing on the property in order to transfer it into your name once you've got the grant of probate. But you're not talking huge sums of money to do that.
Okay. Okay.
But I mean, if you felt that you wanted more protection, the problem with changing names. So if you wanted your name to go on the property, it's better for it not to have a mortgage on the property, because the mortgage company would have to agree to the extra name going on, which means they'd probably have to redo the mortgage. So sometimes I say to people, we'll wait until the mortgage is paid off and then we'll just balance it out and we'll put both names on the property.
So it's been paid out.
So you could do, if someone owns a property and they want it to be passed on to, or they want a partner or spouse to own the other half, then that can be done in your lifetime. But as it is, it's covered in your will. But if you feel more comfortable having your name on the property, then you could. The only thing I would say is, if you're not married, just putting this in there, if you do a transfer of your property to a partner and not a spouse or civil partner, it could be subject to capital gains tax because it is gift. Whereas if you transfer a property into, so let's say I'm a husband and I'd like my wife to be on the title deeds of my home or our home, and so I want to do a transfer to put the property into both our names. Because we're married, there is no capital gains tax. So this is not inheritance tax. This is capital gains tax, which is, oh, actually, no, there's no capital gains tax on your home. I don't know why I've said all of that. If it's your home, it's free of capital gains tax. But if you were talking about a second property, if you're married, there is no capital gains. But if you're not married, it could be subject to that tax.
Okay.
Yeah.
Thank you.
Okay.
Okay. So I'm going to combine these questions. What are the fees for the lasting power of attorney, and are the forms for this downloaded from the internet any good?
You can download the forms from the internet if you want to do this, but like everything, people struggle with filling in forms, and I'm not suggesting for a minute that you're not capable, all of you, of filling in forms, but again, you don't know what you don't know, and people get it wrong, and that can have, quite a dramatic impact, but you might not realize it until you come to use it. So, you can do things incorrectly on powers of attorney, as with anything, if you're not familiar with the forms or familiar with the law that goes behind them. So we always recommend that we help you with them. And so if we're producing the forms for you and going through the process of helping you fill the forms out, or we're filling the forms out for you, making sure that your attorneys assign everything's done in the right order, that the dates are all correct. You'd be amazed at how many people in a date box put their date of birth instead of today's date. That happens a lot. So just making sure that it's all signed in the right order, because there is a specific order for everyone to sign. There is also a requirement for somebody to act as an independent certificate provider. So an independent person who is able to sign to say that they believe the person to be, to understand what they're doing when they're making the power of attorney, that they're not being influenced in any way by somebody, and told to do this, but they don't understand it. So there has to be an independent party who can sign that section. So we provide that service as part of the process. And we also make sure that the documents are checked before they go off to be registered. And we make sure that when they come back from being registered, that they are valid documents, because the Office of the Public Guardian are humans, really, and they make mistakes too. And we have known them to lose pages along the way. And when they've sent documents back to us for our clients, they've had pages missing. So you wouldn't know that if you weren't familiar with the documents, and therefore they're not valid, but they've sent them back to us as valid documents. It doesn't happen that often, but it does happen. So we make sure that when they come back to us that they are valid documents before we return them to you or store them with your wills. And we send you copies at that point. Right, so our fees for doing that is £200 per power of attorney. So if you are a couple doing 4 powers of attorney, that would be 800 plus VAT, which would be £960 plus the registration fees of £82 per document.
Also, is there a limit on how many people you can have on the power of attorney?
In theory, no, there is no limit. However, you just have to think about how that would actually work in practice, because the more people you have, the more accountable they are to each other. As attorneys are so if one person acts as an attorney for the person who's made the power of attorney, it is as if they have all acted. So it can get a bit unwieldy, if you like, if too many people are on the power of attorney. But in theory, you can have as many as you like. I just generally tend to advise a more pragmatic approach. I had a lovely Irish family who the couple had 6 children. So they divided it equally. So the ones that were good with money were on the health or on the financial power of attorney, and the ones who were a bit kinder, but not so good with money, were on the health and welfare powers of attorney. So it worked, and they weren't, they were worried that they might offend one of their children. So they said, okay, that's fair, that's equal, they each get a role to play. But 6 children all acting on the same power of attorney might just have been a bit tricky because they didn't all get on either. So you have to be a bit pragmatic. They've got to work together, and you don't want, in creating these documents, you don't want to create a family crisis. You're trying to avoid that from the start.
What about too few attorneys?
Oh, well, that's a very good point as well, actually, Tony, because yes, sometimes people just appoint their spouse as their attorney, and you know, they're not cheap to do or to register these documents. So just appointing your spouse means that if you both get old and are not so good and you can't act for each other, then you have no power of attorney. Or if one of you dies, the other one may already have dementia and they have no power of attorney and no one to help them. So it's always good to have at least one other attorney or replacement attorney. And I mean, there are situations where people do just appoint one, but I do try and encourage them to consider others as well.
Good.
Okay. If you are single and without a will, and your parents are not alive, how would this work?
Right, so you're single, no children and no parents. If you have brothers and sisters, everything goes to your brothers and sisters in equal shares. If one of your brothers and sisters has died before you, then it would go to their children in their place. So if you've got a brother and a sister and no parents and no children and no spouse, then your brother and sister would inherit. But if one of them has died before you, leaving 3 children, then half of your estate would go between your nieces and nephews of the brother that's died, and the other half would go to the remaining brother or sister. Yeah. If you have no brothers and sisters, it goes back up to aunts and uncles. And if there are no aunts and uncles surviving, then it goes to your first or second cousins. Or so to your cousins and then your cousins' children. As I say, this case we've got going on at the moment, we're into second cousins once removed and no further, but it's a nightmare. And they're all in America. And we're trying to do family trees. And I'm tearing my hair out, believe me. And this was a man who had done his will, but he hadn't signed it. So for the sake of a signature, the people he wanted to inherit are not inheriting at all. I'm trying to contact the relatives in America, but that's proving very difficult. And what are the chances in this post-COVID world that those people in America are going to agree to give up their money in favour of the beneficiaries the deceased really wanted? They're not going to. So, you know, if you've got a phone call saying your long lost uncle has died and he didn't make a will, so you are a beneficiary, but would you like to consider giving it to the beneficiaries that he really wanted to leave it to? How many people are going to say, yes, of course I will, unless you're very wealthy? But he hadn't even met some of these relatives. He'd never seen them. He'd fallen out with his brother 40 years ago and he'd never met the children. So anyway, it's very sad.
Yeah. Mina?
So how does it work for jewelry? I mean, is inherit, if, sorry, 1 minute. I mean, if you inherit jewelry, is it valued, subject to tax or tax?
Well, yes. Okay. So, I probably shouldn't say this. Right. So you are supposed to declare everything you own to HMRC and probate in the event of your death. But whereas a car is visible because you have to register it at a government department at the DVLA. DVLA, yeah. Your cash is visible because it's in a bank account, or if it's stuffed under the bed, no one knows you have it. Your house is obviously registered at the land registry, so it's visible. But what you own jewelry-wise or your personal effects, The only way that anybody knows what you have is if you mention it specifically in your will, because your will becomes a public document when you've died. So it has to be, your will is sent to the Office of Probate and a copy sent to HMRC. So everybody knows what's in your will. So if you mention something specifically in your will that you want to leave to someone, it has to be valued because it is an asset that you've declared. If you don't mention it in your will, but you want to leave assets to some of your personal effects to specific people, then I normally recommend people to do to leave their personal effects to their executors to distribute according to a letter of wishes. Your letter of wishes is not submissible to probate and HMRC, so no one knows what you have on that list. So it's a much better way of giving your stuff, if you like, your personal effects, than putting it in your will. If it's in your will, it draws attention to it. I shouldn't really say that, but it's true. But the other thing to consider is that if you have assets listed on an insurance, contents insurance document, then that is a legal document that you are declaring an asset that you own. So if you've insured your diamond ring for £4,000 and it's specifically on your insurance schedule, then that also has to be valued because an insurance schedule is a legal document. It's a legal declaration that you agree, it's a contract that you sign up to. So HMRC have been known to randomly check insurance documents to see whether something has not been declared on probate, there should have been. But if it's not specifically mentioned in your will and it's not on insurance schedule, there is, although I didn't tell you this, it's very difficult to know what anyone has. And how would HMRC know? I didn't say that.
Okay.
All right.
Anna, do you want to take over?
Does the trust has to be done by solicitors, or is it same that the financial advisor can do that?
Okay. So you said a trust. Is this a trust for a life assurance policy? Okay. So in theory, the answer, if you're setting up a trust in your will, then it's whoever the will drafter is that is responsible for making sure that the trust is correct. But once you've died and the trust is established, then it's up to whoever the trustees of your will are to make sure that the trust is set up. If you're talking about a trust for a life assurance policy, and I'm only referring to that because that was an earlier question, then a financial advisor can assist you with that. And, or in theory, you can do the trust documents yourself. I think for trustees of a trust, it is always better to get professional advice because trustees are in a position where they are obligated, they have a duty of care to the beneficiaries they are holding an asset on trust for. So I would always say it's a good idea to get some advice before proceeding. If you are a trustee of a will or a trustee of a trust, and you are in the position where you're holding funds for someone else, getting advice from a solicitor or a financial advisor would not be a bad idea if you are in that position after someone has died.
Yeah. I've got Ilaben. Ilaben got a question for you.
Okay.
Ilaben, unmute, please.
Hello, Panabin.
Bolo.
Sorry, there was a question I think was just mentioned because that's the one I raised it about the trust. It's a property trust. There's two set of trust. One is for your own main house. So when you explained about the tenancy in common, which is understood, but somebody said it's best to set up a trust as well for your own property. How does that work?
Okay, so if it's a trust, so you're talking, sorry, Ila, you're talking about a trust in a will or a trust in your lifetime?
Trust in a lifetime.
Okay, it depends. So it depends really, truly. People should always take advice on this.
Okay.
Trusts are, I'm a great fan of trusts, but only used in the right way.
Okay.
You shouldn't be doing trust for the sake of doing a trust, because the problem that you've got is that if you put your property in a trust in your lifetime, as I mentioned earlier, it's a gift with reservation of benefit, which means if you're doing it to save inheritance tax, it doesn't work.
Okay.
If you are doing it to avoid care fees, it does depend on whether you are in need of care when you do it, but you should also be aware that depending on the value of your property, you could incur a tax charge in putting it in a trust.
Okay.
Also, if you're putting your property in a trust and the beneficiaries of the trust are your children, because they're not inheriting the property directly from you, you don't get the extra tax allowance, that the extra 175,000 I mentioned, because the property isn't going to your children, it's going to a trust. Even though they are the beneficiaries of a trust, they are not the direct recipients of the property, the trustees. So you could, I never say to anyone, oh yes, putting your home in a trust is a great idea. It really depends on why you're doing it. And I'm not a fan of just having a trust for your home, because it also means that if you give your home to a trust, it's run by trustees. And let's say if you wanted to downsize at any point in the future, so you give your home is worth 600,000, and you and your husband give your home into a trust. And then when you're much older, you decide that you'd like to sell up and buy something smaller. And so you do. So the trustees agree that you can sell that the home can be sold. They're the ones who have to sign off on the sale because they're the trustees of your home. And you buy somewhere for 400,000. So the trustees still own your home for 400, but the difference between the 400 and the 600 still belongs to the trust. It's not yours to use. You have lost control of any capital or equity in the property that you might want to have use of in the future. So this is why I prefer to use a will trust. So you are protecting yourself. It only happens in the event of your death. And you are protected, therefore, because you're not impacted in your lifetime, but you also protect your spouse or your partner with the trust, so that the only impact arises when you're both gone.
Okay.
Yeah.
So, I mean, there was another implication as well, like we have a buy-to-let property which is rented out. So we were thinking of putting that into a family trust. And
Okay.
any income comes on that can go to my grandchildren as a beneficiary.
Okay. Well, yes, you can do that, but just also be aware it might depend on the value of the property, because there could be upfront charges. But yes, I mean, you can certainly do. It's not your home, but obviously you are. If it's a buy-to-let property, you have to be aware that if you put the property in the trust, you are also giving up the income. So if you're relying on that income, or maybe might want to have the option of taking the income in the future, that won't work if you put the property in a trust, because you are no longer then entitled to the income.
No, that's right.
So this is why, yeah, I mean, what you've just said, it works so long as the value of the property is less than the value of 2 nil rate bands, which is, so if it's less than 650 and it's you and your husband own the property, that's not a bad idea, but not everybody can manage without the rental income. So this is why advising on trusts is a very specific advice to a client. I never just say, oh, you should all do trusts. Even asset protection trusts, it has to be right for the client. So I need to know the details of why you want to do a trust, what you're trying to do, what you're trying to achieve, because all trusts are not good.
No.
Okay.
So is that okay then, if we did it this way for my grandchildren, them to have the income for their studies and all that?
Yes, you can do that. Absolutely. As I say, you have to be careful about the value of the trust and also, sorry, the value of the property, but also if the property increases in value, then it may be subject to 10-year charges to inheritance tax, depending on the type of trust. So normally, if it's between all of your grandchildren, you would have something called a discretionary trust.
Yeah.
And in a discretionary trust, if it's over a certain value, then it's subject to 10-year charges. So you know, it may not be huge sums of money, but you might not want to give all of it to the grandchildren until you've paid the charges.
Okay, so something we got to remember if I'm still mentally competent to remember all that.
I know, but again, you know, this is why it's quite specific advice, but it doesn't have to be an all or nothing. But in theory, for your particular scenario, that could work. But it just depends on the value of the property and what you're trying to achieve with it. That's all. Yeah. So, I mean, I'd be happy to advise you on that further, but it would be a more specific bit of advice.
You know,
Find one. 1 second. Quite a few of these have been covered now.
yeah.
Oh, good.
The first one, do others?
Okay, what about somebody? Sorry, oh, no, I found one. What about somebody who has become widowed? Do they have twice the inheritance tax?
Ah, yes. So yes, absolutely. So that again is really important point. So I mentioned earlier that if you are married or civil partnered and you are leaving, you're giving your estate to your spouse or civil partner who survives you. So because your spouse or civil partner, so long as they're UK domiciled, doesn't pay any inheritance tax on your estate when they inherit it, you haven't used any of your tax allowances. So there is something called a transferable nil rate band and a transferable residence nil rate band. So in theory, if you have a couple and they leave everything to each other, or they could have a life interest trust in their will, which is the same as leaving everything to each other, then when the second one dies, they have their own tax allowances as well as their deceased spouse's allowances to use. And it is the allowance that's transferable, not its value. So say, for example, someone I spoke to today has just died, and the person I spoke to today is their mum's just died, and their father died in 1984. So the tax allowance in 1984, I don't know what that would have been, probably about 100,000. But because they left, when their father died, they left everything to the mother. The mother's estate can claim her allowances at 325 plus 175 and the deceased husband's allowances at 325 and 175. So although the allowances were much less when the first spouse dies, it's the allowance that's transferable, but it's calculated at the rate at which the second spouse dies. So in this context of the son who I spoke to today, his mother's estate has potentially £1 million tax-free. So that's her allowances of 500 because it's going to children, and her late husband's allowances doubled up gives them £1 million. Okay, so in this context, the estate value is about 940, so they've just got in without paying any inheritance tax at all. Does that help? Does that make sense? You're looking a bit shocked. So hopefully the tax situation is better than you thought.
Well, it's a bit of magic, Sue. That's the thing. It's a bit of magic.
Well, I'm not resorting to singing and dancing, but I'll try and do magic if I can.
Okay. I have a lot of people saying, can we have your contact numbers, etc.
Right. So what I will do is I will send out the slides, and I will include my contact details on there. I do. I'm not a one-man band. I am a part of a company, and we have consultants and admin staff. So all new leads do come through the admin team. However, there is no reason why you could say, well, you've seen me on a seminar, you'd like to talk to me because there was something I raised or whatever. But my admin team, I would spend all day dealing with emails and phone calls. It feels like that sometimes, but I have an admin team who deal with all the new leads. They log them and contact details, and they will talk to you about arranging an appointment. And if you do want it to be with me, that's fine. That's not a problem. Or if you want to see someone else in my team, that's fine too. Okay, so I'll put all of those details on the email that I send to Pam. Is that okay?
I think that's
If
it.
you had a joint will and one partner passes away, do you need to amend or change the will?
In theory, no.
No?
No. But you can. Yeah. So if you've made mirror wills that leave everything to each other, and then when the second one passes away, it goes to the children, that's a very standard setup. So if one of them passes away, the other one's will should already cater for, so if my husband's predeceased me, if my husband's already gone, my will would probably say, I appoint my husband as an executor, but if he dies before me, then I appoint my children, for example. And similarly, I leave my estate to my husband, but if he dies before me, then I leave it to my children. So usually wills between a couple will cater for the first death scenario and the second death scenario. So quite often couples don't need to redo a will after first death, but sometimes they choose to, and that's fine.
On that question, Sue,
Yes.
Hannah mentioned a joint will, and I think there was a question earlier about joint wills, and I think we need to just make clear that there is no such thing as a joint will, but because everybody has their own individual will.
Oh, yes. Sorry, Tony. Very good point. Okay. So we often talk about mirror wills, but there is no such thing as a joint will. A bit like a passport or a driving license, a will is a legal document that you and only you own. Okay. So each person has their own individual will. Quite rightly, as Tony says, there is no such thing as a joint will. Sorry, when you said joint will, I was automatically thinking that you meant a will that mirrors the other. So one leaves everything to one, and then you say what happens after the second one's gone. So they're just mirror images of each other. That also is often referred to as a joint will. But if you are a couple, you don't have a will for both of you. You have to have an individual will, because in the event of your death, apart from the fact that it wouldn't be legal to have a joint will, but apart from anything else, when you die, your will is sent to the probate registry and then becomes a public record. Your original will has to go to probate, and it is a public record document.
Yeah.
And they don't accept copies. It has to be an original will. So if you had a joint will, if there were such a thing, the other party would have to make a new will, because there isn't a will anymore. It's gone to the public archives, to the public records. So everybody who's ever made a will, whose estate has gone to probate, their will is in the public records and is downloadable on an inquiry. So you can go and download a copy of Princess Diana's will, Henry VIII's will, Churchill's will. Anybody's will is there and visible to view. So this is why I also say to people, and this is what people don't realise sometimes when they do their own wills, you have to be quite careful about what you put in a will. Sometimes people can put, I do not want my sister to inherit anything. She has always been horrible to me and blah, blah, blah. And they put some horrible message about why they don't want their sister to ever inherit. And that they don't realize that that is actually out there in the public domain in the event of their death. And, you know, that may never have been what they intended. They might have just wanted their sister to know how they felt, but now everyone knows how they felt about their sister, if they choose to go and look at it, of course. Okay, so it's worth noting that if you get it wrong, you can get it very badly wrong.
Without a will, if one wife dies, husband is not aware of the income or asset, can next of kin can find this from anywhere as to what the person hold?
It's more difficult, but in theory, yes. If you are appointed as an executor of a will, you could write to all of the banks saying, here is this person who's died, here is their death certificate. Do you have any accounts for this person? Okay. So in theory, you could, and the bank would have to let you know if they did. On production of a death certificate, obviously you can't do that until you've got a death certificate, because otherwise, you know, no bank is going to give you that information unless the person has died. But yes, in theory, you could. It's not easy because, you know, there's an awful lot of banks or investment companies or whatever else out there. What quite often happens is that one of a couple dies and the other one dies a few years later, and they've got all these shares, and you suddenly find that some of the shares were actually in the name of the husband who died years ago, and now you're stuck because you can't deal with them because you're not the executor of their will, you're the executor of the second person's will, and it can be a bit of a nightmare. Mm-hmm. So it's quite common, I have to say. But yes, in theory, you could write to every single bank or investment company and say, are you holding any assets? There is an asset search company that you can do online, but it's not an exhaustive list because it only applies to the companies who sign up for the search. So if all the high street banks signed up for it, and most of the investment companies, you'd have quite a good outcome. But you could still find that the person has an asset with one that hasn't registered up for the search facility, and you'd never know. Sometimes assets do come to light a lot later.
Mm-hmm. Yeah.
Okay, I hope that helps.
How are we doing for time, Pan?
Yeah, we're after 9:30. I might have a...
On overtime now.
Yes, it is overtime. So what I'm going to do is I'll send you the whole chat list, and you can reply the last lot which we've not managed to read to you. So if you can answer those questions back to me, I will put it out to them again. And yes, Cornerstone, how long do you hold our wheels for? How long? And I think until death do part us.
Well, yes, yeah. I mean, we hold them until someone dies, in theory. I mean, obviously, you know, I might retire someday before the person whose will I have dies, in which case we would either return the will, or if we are bought out by another company because I retire, not that I'm planning on it anytime soon, but if I did, then obviously the new company would then be responsible for the storage contract with the client. And if they didn't want to store the wills with the new company, you could simply have them returned. Okay. Yeah. Just also bear in mind that I will do my best to answer the questions as quickly as I can, but I am extremely busy right now, and I know that sounds like a cop-out, but I really am. So bear with me. I will work my way through the list, but please be patient, because I may not get to you before the weekend, but I will do my best to get to you within the next few days.
Great. Otherwise, you've got your assistant Tony with you.
Absolutely. Tony can help me. Yes.
So I will be emailing it to both of you anyway.
That would be perfect.
Whoever
Thank
gets
you.
the chance, get to it.
Yeah,
Sure.
Tony, you attack the list first, and then I'll add whatever else.
Sue and I do work very well as a team, so that's it.
Yes, I gathered that. Thank you very much again, ladies and gentlemen, for joining in. Before I do my update list, can I introduce you one of our admin who is also there, Sarojben. I'm just gonna spotlight her as well. She's one of our admins as well. So can I just update you with our upcoming events? As you know, Friday, we do yoga in the afternoon at 2:30, so try and join in. We're going to celebrate Valentine's Day, so dress up in red, and we have actually got professional singers to entertain us for 2 hours. And then Saturday morning, we have got another 1.5 hours of yoga, and then in the evening, we've got Ekadasi, so try and join in for our Ekadasi. Sunday morning, we've got meditation at 9 o'clock with BK. So please try and join in for our meditation as well, which is wonderful. And then again, celebration with our Kalash radio on Valentine. So try and join in for that as well. I will be putting out the links into our events group. So look out for all those links, and it will be great for you to join us and see our entertainment. And our new motto is for the resolution is to bring 1 extra or 2 extra people with you. So, we just want to build up our name, women to women, as we have been bringing up so far, entertaining the ladies. And what more can I say? But it's great. We've got 30.
What a lovely group you have. What a great idea.
Yes.
Lovely. You're a bit outnumbered there, Tony, I'm afraid.
Susan, you can join us.
Oh, yes.
Thank you. One more.
Yeah.
Anyway, thank you very much, all ladies and gentlemen.
Thank you. Very nice presentation.
Especially Sue and Tony to give us your precious time. And I'm sure everybody thoroughly enjoyed it. There are still more questions coming in, so which I will be sending it to you. Keep you busy over the weekend. Have a lovely weekend, and hope to catch up with you, Tony, soon.
Yeah,
Take care all.
Thank you very much for your time, everyone. And thank you for giving me the opportunity to talk to you all. It's been an absolute pleasure. Thank you.
Thank you.
Love to see
Great
you
questions.
as well.
Oh, terrific.
Thank you.
Well done.
Thanks.
Take
Bye
care
bye.
all.
Thank you.
Thank you, everybody. Have a nice, what's left of your evening. Bye, Tony.
Bye
Bye.
Bye, Susan and Tony.
Bye.
Bye.
Bye-bye.
Bye, Sue. Bye, Panna.
Bye-bye.